International Students and Scholars here at Bentley. And I am joined today by Audra Bonney, who's our Senior Associate Director, Graduate Career Development, also International Students Specialist. And then we have,
sorry about that. Go ahead.
We have Ayandoli Design Cronin here with us, one of our partner immigration law firms. We have Prasant Desai and Allison Howard Yilmaz here, who are going to give us some information about your post-OPT options.
Okay.
So I jumped the gun a little bit in the introductions, but yes, here are our presenters. So first, before we get started with the presentation from our attorneys, Audra is going to give a little bit of a summary of some general information and resources from the from the career development side, actually. And I am also going to give a very, very brief summary of your F1 work authorization options. I know some of you are already on your OPT and STEM OPT. In fact, the vast majority of you are, but for those of you who may still be students, we will just go over a very brief overview. And then again, Prasant Desai and Allison Howard Yilmaz are going to go over some post-OPT options, including the H-1B, other types of employment, and also immigrant-based visas. And then we will open it up at the end for some questions as well. So this session is recorded, so we hopefully will be able to provide you all with a copy of the recording in the coming days as well.
And I think it's my turn to introduce myself quickly, but I did want to encourage students, as you have questions, it's a heavy topic. There's always a lot of questions in this session, and we encourage you to ask them. There is a lot to cover, so we do encourage you to put them in the chat, and we'll do our best to address them as we go and at the end as well. Okay. So just a few slides from me. As Anna had mentioned, this session is really meant to be focused on the options after OPT, but I do appreciate the opportunity to collaborate with the Center for International Students and Scholars. For those who don't know me, my name is Audra Bonney, and I represent the Pulsifer Career Development Center. Formally, as Anna had mentioned, I am the Senior Associate Director and International Student Specialist for the group. But I did want to say that if an international student, of course, he has a question, you can always reach out to me as the representative in our office. But to know that we do have a wonderful staff and lots of resources for each group of people that is here today. And we are cognizant of the fact that we have undergraduate students, we have graduate students, we have alumni that are here. So welcome to all of you. So good to see you all, and we hope that we address some of the questions that you have. So again, just in terms of graduate career development, what I'll do is put in the chat kind of how you can reach out to us. So for graduate students, we have the Graduate Career Development Office. For undergraduate students, UCD, and of course we have resources and support for alumni as well. So again, I'll add those emails in the chat after my few slides. Okay. And then, you know, again, just wanted to make reference to and remind all of our international students and alumni that there are a lot of resources that are available to you. And here on this slide, there are just a few specifically that I wanted to remind you of and make mention of today. So for students only, we do have Handshake. And a lot of these resources are listed on Handshake as well. I do want to encourage you to use Handshake for a variety of reasons, making appointments, applying for opportunities, as well as events like this, signing up for events like this. So Handshake is really a place that is kind of a one-stop shop for all things career development for students. So I encourage you to use that. For all populations, undergrads, grads, for alumni, the rest of the resources that you see on this slide are available to you. So InnerStride is available to alumni, again, and students as well. It's our primary resource that we invest in and that we really encourage international candidates to use on a regular basis. We have about 650 or so alumni and students that are on the platform. And many of the students who have used it really enjoy using it for the information it provides, for the opportunities to learn through webinars. And in specific, students have mentioned and alumni have mentioned the resource, the Visa Insights, a way for you to determine a list of companies that have sponsored in the past. It's really valuable. So feel free to use InnerStride. Going Global, again, is a similar resource. And again, what I'm going to do after is to add all of these links in the slide so you can review them at another time. And again, just know that they're available to you. On the bottom, we have EFMD because we have been EQUIS and international accredited. We do have access to EFMD, which stands for the European Foundation for Management Development. There's lots of great information there, as well as events and virtual career fairs. So just to make sure that you're aware that we have that. And then for our Chinese students and alumni, AUCA, which stands for the American Universities China Association, there's a variety of spring events for any of you who might be interested in working and interning in China. There are spring events that are going to be taking place in March and April. Go to our WeChat official account, which is Bentley Graduate Career Services, and you'll find more information there. So these are the resources that I wanted to share with you today, just briefly. And then refer to, for students, there's a lot of events coming up. So again, encouraging you to visit Handshake and make sure that you don't miss out. So on that note, I'm going to pass it over to Prasant and to Allison to begin the robust conversation about options after OPT.
Audra, I think there's a section, we have a section first, the CISS section, and then we'll—
Oh, sorry. Sorry about that. Anna's next.
All right, so I will keep it brief so that we can pass it over to our attorneys, but I want to give just a brief summary of our Center for International Students and Scholars resources that you have. So most of you have visited our office before. We are on the 3rd floor of the Student Center in Suite 310. We're currently still doing hybrid operations, so you can reach us in person and virtually, and I've listed our contact information here. So I just want to remind you that that the CISS can help you with your F1 benefits. So these are, there's specific work authorizations that are benefits of your F1 visa, not visas themselves. They don't require sponsorship. We can help you with CPT, so that's curricular practical training for internships for credit while you're still a student. OPT, so that's optional practical training, which is generally used post-graduation. You know, it's for 12 months per degree level. To work or get practical experience in your degree field. And then if you are in a STEM degree, so science, technology, engineering, and math as determined by the zip code listed on your I-20, you may be eligible for an additional 24 months extension. So that those 3 types of work authorization, the CISS can help you with preparing for, and we do have presentations on all of those. But today, again, we're really going to be focused on the post-OPT options. Audra, do you want to, I think it's on, do you want, it looks like it's not on presentation mode anymore.
If you feel free to continue.
Okay. So just very briefly, for those of you who are not yet on your OPT, so there's 2 types of post-completion work benefits that you can apply for that are, again, benefits of your F1 visa, optional practical training, 12 months of work authorization approved by USCIS. You get what's called an EAD card for your work authorization in order for you to get training in your degree field. You need to attend an information session hosted by our office, the CISS, and then you'll submit certain materials to our office for review in a new I-20. And then once you receive that, you file your USCIS application online or by mail. And then, as I mentioned, there's STEM OPT, which is a 24-month extension of that. Very similar process in terms of what you need to do through our office. You'll compile some documents, and then we will issue you a new I-20 for you to be able to file through the government. So that is very, very briefly your F1 work authorization options. And I believe that was the last slide on, some information about our upcoming information session. So if you're not on OPT, or even if you're still a student and you're thinking about an internship for CPT, we do have some upcoming information sessions. So make sure that you attend one of those if you want more information. I also want to mention that our office is available to help you during your transition away from the F1 visa. We cannot provide, the light went off in here. We cannot provide in-depth advising on the H-1B or other types of immigrant, non-immigrant visas, but we do help you if you end up being sponsored or being selected in the H-1 cap. We do offer advising on that in-between period. You may be eligible to have your OPT extended, or it's an automatic extension between the time when your OPT ends and your H-1B would potentially start. So I know that Prasant and Allison are going to discuss today more about the H-1 process itself. But before we jump over to them, and as we open it up to Prasant and Allison to take over the presentation, if there's any F1 related questions, please feel free to put those in the chat, and I will do my best to answer those as we're getting Prasant and Allison set up.
Great, thank you so much. Let me start with sharing my screen, and then we can get going. Well, thanks so much, Audra and Anna, for introducing us, and it's a pleasure to be here to help your students and alumni, navigate the immigration process. Now, before we begin, I do want to make clear that all the information we're giving out today is just informational in nature, educational, informational in nature. We're not intending to create any kind of attorney-client relationship through these slides and this talk. And also know that any questions you ask us are not protected and or private, because they are in a public forum. So if you ask us any questions, everyone in the world, you should assume everyone in the world is going to know the question and the answer or the response. So when in the chat room and when you're asking us questions, make sure to make them general in nature. If you have specific questions about something in your background, then it's wise to seek out a professional on a private basis. But this is not the place to do it. Now today, Allison and I will be giving you a really broad overview of the immigration landscape in the United States. So the basics of our immigration system. We'll talk about some of the non-immigrant visa statuses that are possible for most professionals after they finish their OPT or STEM OPT, depending. And then we'll also talk about the green card process, and Allison will talk extensively about that. Now, we are limited in time, so everything we're going to talk about is going to be very basic in nature. And so everything we say, sometimes there'll be exceptions to some of the information we give you. And we don't pretend to give you all the law. It's quite expansive. So whatever we, talk about today, understand that there could be exceptions that are applicable to your particular situation. Now, the U.S. system is really based based on the Constitution of the United States and what's called the Immigration and Nationality Act. And those two documents divide the world into two, basically. There's U.S. citizens and there's non-citizens. And on the U.S. citizen side, we have people who are born citizens at birth, and anyone born in the United States generally is a citizen at birth. So if you're born within the territorial jurisdiction of the United States, you're a citizen. The only time there's an exception is if your parents were diplomats and not subject to the jurisdiction of the United States. then you're not automatically a citizen. But everyone else, no matter what your status is, if you have a child in the US, that child is a US citizen at birth inside the US. There's also the law of blood. So if you're a US citizen and you meet certain residency requirements, if you're living abroad and you have a child, in some circumstances, that child can be a citizen at birth. It really depends on some complex formulas about residency. So if you, haven't spent much time in the US, you were born here and then you immediately left, if you have a child outside the US, chances are that child is not going to be a US citizen. So there are some residency requirements. The other way to become a US citizen is through naturalization. And that's a formal process where you apply to the government, to the Department of Homeland Security, and ask to become a citizen of the United States. Now, generally, most people will have to be lawful permanent residents, green card holders, for 5 to 3 years before they can apply and become eligible to apply to become a citizen through naturalization. Now, on the non-citizen side, we have a large group of individuals in the US. We have immigrants. Those are people with green cards. If you have a green card, it's synonymous with being an immigrant in the United States, or a lawful permanent resident. So those are the same things. A green card is basically an identity document. It's basically the size of an EAD or a driver's license. It has your photo on it, and it has your date of birth and your place of birth. But it basically identifies you as a permanent resident of the United States. And what that means is that you get to reside in the US permanently as long as you don't commit certain acts or commit certain types of crimes. And as long as you make your home in the US, you can keep that for a lifetime. It also allows you to work pretty much for any employer in any job in the US. There are some jobs that are restricted just to US citizens. So usually those are law enforcement jobs or jobs involving national security. The other great group of non-citizens are non-immigrants within the United States. And so those groups, you're one of them. As an F1 student or F1 student on OPT, you're a non-immigrant. There are about 80 different types of non-immigrants, and it's basically an alphabet soup from A all the way to W at this point. And each of those categories has subcategories, and each of those subcategories has privileges and restrictions. And so what we're going to focus on in our talk are the employment-based subcategories that are available after OPT. So we're not going to talk about all of the employment-based categories, just the ones that are relevant really to professionals. The other great group of individuals in the US are people who are refugees, asylees, people on temporary protected status, people here as young children under the DACA program. And these are basically humanitarian type statuses. They're not pure non-immigrant statuses, so they don't automatically lead to anything. But if you have these statuses, generally you can stay in the US and get work privileges. And then the last group of individuals are people without a status. And so these are individuals who might have come to the US as students or visitors and overstayed or stopped studying or worked without authorization, whatever, and they became present in the US without a status. The other group of individuals are people who came to the US without being inspected by a Customs and Border Protection officer. And those people, as soon as they got into the US, they were here without a status. So just because you're here without a status doesn't mean that you came, in a particular manner. You can't, assume that a person just came across the border without a status. Many individuals come here on one status and do something inadvertently even and violate that status and immediately become, without a lawful status. Now, some non-immigrant basics. It's always good to go over these. I know that Anna goes over these with you, and her team, I'm sure, impresses on you the importance of always maintaining status. And we'd like to take at least a moment to, again, emphasize how important that is. And that's because if you lose your non-immigrant status, it becomes very difficult and complicated to go on to become a permanent resident in the United States. And it adds all sorts of complications to your life here. that make it very difficult to move and to change statuses. And so that's why we want to talk about these basics. Now, there are two principal agencies involved with non-immigrants. One is the Department of State, and the other is Department of Homeland Security. Now, Department of State is important because they're the ones who stamp your passport and issue visas. So you have to make sure to abide by their rules. Now, once you have an appropriate visa and you come to the US, it's up to the Department of Homeland Security to admit you. And once you're inside the United States, then you really have to be cognizant of the Department of Homeland Security's rules and regulations, because they're the ones who control what you can do while you're inside the US. Now, you can only come to the US in one category at a time. And this is really important for students who have an F1 visa, but might have a tourist visa also. So if you're traveling, you're going home for vacation, you're coming back on your F1, you talk to Anna's team and they gave you, an I-20 appropriate for travel and all of that, you might be, the officer at the airport might admit you as a B1 tourist because you have a tourist visa in your passport, again, by mistake. So you have to make sure that as soon as you arrive in the US, you check your I-94 to make sure that you were admitted in the right category. All right, so that's really important. Always print out the I-94 from the CBP website. Sometimes there are mistakes on that. Again, the biggest one is you're admitted in the wrong category or for the wrong duration of time. Now, if you're here in the US in a proper status, you're maintaining your status, most times you will be eligible to change your status. And if you're going through the H-1B process, the employer will help you with that change of status process. Also, once you're here, let's say in a particular status, you can get extensions of status. Again, there are limitations on that, and requirement generally is always you need to be in a proper status in order to get a change or an extension of status. Now, let's say you get a change of status here in the US, you go from F1 to H-1B. That's great. Department of Homeland Security has authority to change you from F to H. But as soon as you travel, in order to come back, you need to get a new visa in your passport in the right category. So in the H category, again, you'll need to go to the US Embassy or consulate nearest you and apply for that admission, that stamp, so that you can come back to the US in the H-1B. Now, these are some of the typical professional work categories that are available to most professionals. H-1B, we're going to talk about extensively. The H-1B one is just for Chile and Singapore. It's for work in a professional specialty occupation. The TN classification, it's limited just to Canadians and Mexicans. It's based on the old NAFTA treaty, and now it's called the US Mexico-Canada agreement. The immigration provisions are pretty much exactly the same. There's the E3 category, that's for Australian nationals and citizens. The O1, we have some slides on the O1. It's very limited because it's available only for people who have really reached the top of their profession or their field of endeavor. E1 and E2 visas, those for treaty traders and treaty investors. Your country has to have a treaty with the US in order to be on that, eligible for that type of visa status. We have a slide on that as well. The L1, the intercompany visa transfer, that allows for multinational companies to transfer their valued employees from abroad to the United States. Generally, it's limited to employees who are very specialized or managerial or executive and need to have worked abroad for at least a year before coming here. There's the J1. We've put it in there because if you have a J1 and you finish your program as a student, you can get academic training. It's very similar to what OPT is, but it's available for students in the J1 category. The F1, which Anna talked about, you get your OPT. It's really valuable, and make sure to follow all the rules to get that. And then if you're in a STEM program, you can get 24 months on top of that. But remember, there are additional requirements for that. The number one being that the employer has to be an E-Verify employer, and they do have to have a training plan in place for you before you can start work, basically. Now, the H-1B, we'll talk about the basic criteria, the annual quota, some limitations or benefits, really, and then the alternatives to the H-1B. And the reason why we talk about the alternatives has everything to do with the annual quota, and you'll see how ridiculously small it is compared to the size of our economy. Now, the basics of the H-1 program are that you really need to have a U.S. sponsor you, a U.S. employer sponsor you. So you cannot get your own H-1B. You can't write your own ticket. You have to have a U.S. employer sponsor you. And the job that they sponsor you for needs to be what's called a specialty occupation. And a specialty occupation is defined as a job that requires at least a bachelor's degree in a specific specialty or very narrow related specialties. So that, for example, if you had a job as a sales agent and the employer said, we'll take anyone with a bachelor's degree, it could be in economics, it can be in accounting, it can be in English, it can be in communications, we don't care. That will not qualify as an H-1B job. So when you're going for your OPT experience, you have to make sure that the job is directly, of course, related to your major, and that's great, but you have to make sure that the employer is willing to state, to the US government that the job requires at least somebody with a bachelor's degree with your background or something very related to your background, your academic background. Now, in order to participate in this program, all employers need to promise the government that they will pay you what's called the required wage. Now, that's the higher of two wages. What they pay other people at the locality where you're working, or the prevailing wage, what other employers pay people in similar roles in that locality. So whatever is higher, that's the required wage. And that's what the US employer has to promise to pay you. So it depends on the job and what the requirements for the job are to come up with that figure. So most employers will have their lawyer look through the job description and the requirements and come up with what they believe to be the prevailing wage. Then that lawyer will talk to the employer to say, okay, so what are you paying other people with the same kind of qualifications in this particular role? Whatever that figure is, that's what needs to be offered to the H-1B candidate. Now, this is an unstated kind of requirement, but immigration will want to be assured that this is a genuine work opportunity. That means a bona fide employer-employee relationship, and where they really are probing in their analysis of this is with startups, is with companies that are more in the nature of job contractors. They want to make sure that you, the candidate, H-1B candidate, will be supervised. And they want to make sure that throughout the period of time that they request on the employer requests on the petition, that you'll always be engaged in a professional role in a professional level. So for example, if it's a small company with maybe 3 or 4 employees, and they want you to be a full-time accountant for them, immigration will be very, very curious to see how that type of position is justified in a small business. Now, if you're an accounting CPA firm, that makes all this, that makes sense, right? But if you're a pizza shop on the corner, it doesn't make sense. And so immigration will look at the nature of the employment and the nature of the employee or the work opportunity to make sure it's bona fide. Now, one thing you do need to know is that you as the candidate need to have the degree that's required for this job or equivalent at the time the employer is ready to file their petition. So you need to have that in hand. And this was a problem years ago in the old system when we had to submit petitions on April 1. And let's say you're a graduating senior, you wouldn't get your degree until May. You wouldn't be eligible to be put into the H-1 lottery at that point. But because the system's changed, and I'll get to that in a couple of slides, it is possible for you to now get into the lottery, even if you're a graduating senior or you're getting an MBA, but you haven't quite finished it yet. Now, one of the great benefits of the H-1 program is that it allows for up to 6 years of work authorization in the US. So an employer can ask at any one time 3 years at a time. So it's a pretty good chunk of time, 6 years, for that employer and for you to develop your career here. And it also allows for what's called dual intent, which is this concept in the law that says that even though you want to live in the United States permanently, you cannot be denied an H-1B, which is technically a temporary visa. You cannot be denied that just because you want to live here permanently. So that's written right into the statute. So that can't be the reason why they can withhold an H-1B for you. Now, that's significant because if you're here as a J-1 or an F-1, if you would have told the consular officer, look, I want this F-1, but I want to stay in America forever, they probably would have good grounds to say no to your F-1. And because F-1s are really strictly, you have to show that you have a home abroad that you're going to return to eventually at the end of your studies. That's not required for H-1B. So it's really important. That's why H-1B is such a great visa opportunity for young professionals or professionals who want to establish a career in the US. H-1Bs are open for full or part-time employment. So that's important to know. If you're seeking opportunities at an employer that might not have a full-time opportunity for you, you can also educate them and say, look, I can be sponsored for a part-time job. Now, once you actually have an H-1B status in the US, you can have other employers petition for you for concurrent work. So let's say you're working for employer A in Cambridge and employer B in LA wants to hire you for 10 hours a week, let's say remotely. Employer B can petition the government for their own H-1B for you on a concurrent basis. And so then you can work for more than one employer. Each employer has to have their own H-1B petition in place for you, but it is allowed. Now, part-time studies is allowed while you're here as a H-1B, as long as you're fulfilling the terms of your H-1B work. So as long as you're abiding by the H-1B petition as described to USCIS, US Immigration, then you should be able to study on the side. Now, if you study on the side and get a degree, you will not be eligible for OPT or the other benefits that come with being a full-time F1 student. So just bear that in mind. Also, if you're dealing with a smaller or newer employer, make sure to tell them and educate them that this H-1B process is not competitive in the sense that you're not required to go through a labor market test, or the employer is not required to advertise for the position. There is a posting requirement, but that's related to the salary offer. It's not related to whether US workers were available for the job. So it's important for prospective employers to know that they don't have to advertise in the Globe or anywhere else. Now, your dependents, your spouse and your children, they will be able to come here as H-4 status holders. Most H-4 spouses are not allowed to work in the US. There's a small subset that will be eligible for work authorization. But that is if your employer takes steps to sponsor you for a green card, and then your spouse might be eligible for the EAD, but the vast majority are not eligible, but some are. Now, if you're here as an H-1B, if let's say you decide to leave your employer, generally, if there's a termination in the work, you will be allowed up to a 60-day grace period. But it's not always 60 days, so you have to check with your lawyer to make sure how long your grace period will be. So it's up to 60 days. It's not always 60 days. So this is the quota. This is the big Achilles heel of the program. And it's sad that the numbers haven't changed since 1990 when this program really was implemented. So usually there's 65,000 new H-1B available every year. In 2004, 20,000 were added to that, so 85,000 now. Those 20,000 are reserved just for people who have at least a U.S. master's degree or above. So that's the quota every year. So there's basically 85,000 new ones available. As Anna had mentioned about cap gap, that is really important now. That's a new development that came out in 2008. Basically, every year the visas become available on the first day of the federal fiscal year, which is October 1. Now, if you graduated in May and you got your OPT, let's say in June, there's always a gap, between your work authorization and the time your H-1B will kick in. So in 2008, they developed a program called Cap Gap. And basically, if your H-1B, if the employer's H-1B for you is selected in the lottery and it's undergoing processing, you will be eligible for an extension of your OPT through October 1 or until immigration makes a decision. And hopefully it'll be a favorable decision, then it will go all the way to October 1 for an automatic extension of your OPT and your presence in the US. In order to get that extension, it's not truly automatic. You still have to go visit Anna and show her, your H-1B paperwork so that she can issue the I-20. So remember that. Now, there's a whole subset of employers that are not subject to the quota. Those are colleges, universities, very closely affiliated nonprofits to colleges and universities, and then nonprofit research organizations and nonprofit governmental organizations. Those organizations never have to worry about the cap. They can hire as many H-1Bs as they want all year round. Now, the way that the lottery works is that between March 1, this year it's between March 1 and March 18, employers will get to register their candidates for the lottery. And the registration process is fairly smooth. It doesn't require that much data from the employers. It's a nominal fee of $10 per registration. And basically the employer submits through their attorney or by themselves the candidate's name, their date of birth, their gender, their passport number, their nationality, and whether they're seeking consideration under the 20,000 visa numbers that are reserved just for US masters, if they're eligible for that. So all of that information is submitted electronically. And then on basically March 31, that night of March 31, immigration will run a lottery, electronic lottery, and all the winners will be announced, or the selectees really, will be announced April 1. The employer will get an email to their email address that they registered with saying, there's been an update in the system, check your, registration. And employers and their attorneys will get the same email. And then those who are selected will be, for those individuals that are selected in that lottery, employers will have 90 days to file an H-1B petition for them. And that's where it becomes important and allows for graduating seniors or graduating MBA people to participate in this lottery, even though they don't have the degree in hand, because there's that 90-day window. The employer can file the petition after you get your degree in hand. So that's a huge change. That's significant. In the olden days, we used to have to get letters from registrars saying, this person's completed all the requirements for the degree, please consider them, as having the degree. And sometimes it would work and sometimes it wouldn't work. But now, because of this 90-day cushion, if you're selected in the lottery, you'll have that time to get the degree. Now, if you don't have the degree at the end of the 90 days, that's bad news, because then the employer won't be able to file the petition for you. Now, the Immigration Service will first run the general lottery, so they'll get everybody that's applied, all the registrations, run the 65,000 visa lottery. And then all the people who have US masters who weren't selected will have their own lottery of 20,000. So if you have a US masters or higher, you have a better chance of being selected in the lottery. Now, the exemptions I talked about really, quickly, they're pretty limited to basically employment by a college or university or nonprofits. So those are important. If your career is going to take you into academia, then think about that you don't have as much work to worry about as far as the H-1B being available to you. Now, one caution is that if you do get if you are employed by a college or university in an H-1B, because you haven't been counted against the lottery, if you ever decide to move on from the university to the for-profit world, you will have to go through the lottery. So the transfer process can be a little tricky at that point, and employers will have to, account for that. Now, so many, basically there are about 300,000 registrations and only about 85,000 are selected. So you have to think of alternatives. And unfortunately, most of the alternatives are based on your nationality. So if you're from Mexico or Canada, there is the free trade agreement, the TN status available for you. It's only available for about 63 occupations. So it's not as flexible as the H-1 in the sense that every specialty occupation would qualify. It's only the ones that are listed on the treaty. And the process is fairly smooth in the sense that it's not that expensive for employers to go through this process. The other visas, the H-1B1 and the E-3, it's very similar to the H-1B in that it has to be a specialty occupation, but it's limited to Singapore and Chile. The advantage of these other visa statuses is that you don't have to necessarily go through US immigration. The employer can deal directly with the US Embassy and have you go to a US Embassy and apply for these visas without getting pre-clearance from USCIS. The huge advantage with Australia is that your spouse will be eligible for employment authorization once they land in the US in the E category. E1, E2, I'll have these slides up. If you're from a country that has a treaty with the United States, there might be possibilities for you through your trade relationship or through investment in the US, in a US company, or through the creation of a US company to come here under these statuses. They don't automatically lead to anything, but as long as the company is in existence and the relationships are the same, meaning that there's an ongoing trade relationship or a commercial enterprise in the US, that's employing more than your family, then you should be eligible for the E2 pretty much indefinitely. They can go on for many, many years, but they don't automatically lead to anything. So if you are going to get one of these, you have to think about the future and what your plans are. The L1, it's for multinationals. It's really useful visa even for smaller companies. So you don't have to be a huge company to exercise the L1 or be part of it. It does require you as the candidate to have worked abroad for at least a year in the last 3 years before coming to the US. So if you're here as a student, you probably won't qualify for the L1. But if you go back to your home country or to any other country and work there in a managerial or specialized role for at least a year, and that company has a qualifying subsidiary or parent or affiliate organization in the US, you could be sent back to the US under the L1. Now, if you come here as a L1A, which is for managers and executives, there's a fast track to the green card. And you don't have to go through this long process that Allison will talk about in a second. The L1B doesn't automatically lead to a green card. And the company would have to sponsor you through what's called labor certification generally, and Allison will talk about that in a moment. The O1, I'm putting the slides here, but it really is not applicable to most people who are graduating from school. It really is a very demanding visa classification. It does require a US sponsor, employer to sponsor you, but you have to show that you're one of the best people in your field right now. So if you're just graduating with an MBA, you're not going to be there yet. But if there are exceptions to that rule. but it's really a demanding visa classification. You have to show a major international prize, such as the Nobel Prize, that's in the regulation itself, or at least 3 of these 9 that we list. And just by meeting the 3, it doesn't automatically get you an O1A. You still have to show that all that combined in its totality shows that you're one of the very few at the top of your profession, which is a tall order for students. It really is reserved for scientists and postdocs and people like that. But it's sometimes we do encounter students every now and then who might qualify. But so that's up there for your, for your reading pleasure. And now Allison will take over on the other pathways.
Thank you, Prasant. I'll give you a breather now. As Prasant had mentioned, all of those visas were non-immigrant, meaning temporary in nature. And so really the pathways to make it more permanent are to look at the pathways for permanent residency. And because we're talking about employment visas transitioning from an F to possibly an H, fingers crossed, then we're really going to focus on the employment-based pathways. But there are other pathways. And so this is just a quick little overview of some of the other options for permanent residency. Family-based is another very, very popular one, which I'll talk very briefly at the very end. But another popular pathway that people like to ask about is a diversity lottery. And that's where it's truly a lottery where the US has identified underrepresented nationalities from different countries. So not every country qualifies, and they have to be sort of underrepresented as determined by the government. And every year you can register in the lottery. It's a free process with the US government. So if you do anything online and they ask you for money, definitely don't do that because it's a free process. So you want to make sure that you're doing it directly with the government. And we bring this up because a lot of people ask about the immigrant intent, because if you're here on an F1 student visa, a non-immigrant visa, will it impact your non-immigrant intent if you even apply for the diversity lottery? And the odds are so much not likely to happen that it does not impact your non-immigrant intent being on an F1 student visa. If you are selected, however, then that's a different story, and it's advisable to talk to an attorney, at which point you need to figure out what status you're in and when to file. Another type of pathway to the green card is the investment visa. That's the $1 million visa. Again, if you're just graduating, you might not have $1 million to invest, so we're not going to spend a lot of time on that. And then, as Prasant had mentioned earlier, there are some more humanitarian categories and statuses for people. That's the asylees, the refugees, and unfortunately the VAWA, the Violence Against Women Act. So those are some other pathways that are available, but we're going to focus on the employment side. Prasant, I'm going to ask, can you just skip one more slide ahead? Yes, so the way the green cards are broken up is that they're broken up based on categories, employment-based categories, and countries. So there's only 140,000 available immigrant visas, green cards available per fiscal year. And that is broken down not only by categories, but also by countries or by nationality. It's by country of birth, not by citizenship. And so no one country can be allotted a higher percentage than another. So sometimes what happens is there's a significant backlog in some of those countries for certain countries, some of those categories in certain countries. And this is the sort of visual to that. So as you can see, we have employment-based categories, EB1, EB2, EB3, and it's broken down into these main countries. And you'll see that China and India, who have the largest populations, also have the longest queues to wait for those green cards because they can't be allocated in a larger percentage than another country. So if you're from Norway or France, you're going to fall under the sort of all other category. But otherwise, this visa bulletin is prepared every month by the Department of State and oversees the allocation of those 140,000 green cards each fiscal year. And so it becomes sort of your go-to guide when you're thinking about getting the green card. Now, if we can go back to the first one, yes. So these are our categories. They are broken down into the EB1, EB2, and EB3. EB1, that's the persons of extraordinary ability. That's the Einstein visa. That's the parallel to what Prasant was saying is the O1. So that's really a very tough threshold to meet for the green cards. And I'll talk more about that. Then there's also an EB1B, which is an outstanding professor or researcher. So if you're in academia, this is a very good pathway, especially if you're from a country that's oversubscribed or has a long waiting queue in some of the other categories. And then the alternative of an L1A, if you are on an L1A, you didn't get in the lottery and you go back and work for a multinational company in a managerial role for a year, and then they transfer you to the US, the EB1C is a pathway to that kind of green card that's designated just for L1As. So that's the that's the EB1 categories. EB2 are reserved for those with master's degree or the equivalent. And there's different ways to get the green card or get the immigrant petition as an EB2. It's either through the labor certification process, which is employer sponsorship, or a national interest waiver, which is you're asking the government to discretionarily waive that labor certification process. And I'll talk about that in a second. EB3 is really for bachelor's degree holders and skilled workers. And the pathways for that are through the labor certification process. And so that labor certification process means an employer is sponsoring the foreign worker. Again, the EB1A, there are some exceptions. The EB1A and a national interest waiver can be self-sponsored, and I'll go over the criteria more in depth in a minute. But for the labor certification, this is the opposite of what Prasant was talking about for having to test the labor market for an H-1B. The H-1B is temporary in nature, so the employer has more ability to control hiring an H-1B worker, a temporary worker, and also more control over that wage, the required wage that they have to attest to paying. With the green card side and the labor certification process, the employer does have to test the US labor market and be able to show that there's no minimally qualified US worker. And so this is sort of an overview flow chart. I like to see things visually in terms of how that process works. So the first step is working on the labor certification process. They have to submit a job description with any special skills and the geographic location to the Department of Labor. And then the Department of Labor makes that determination for what the company must pay for that position, a permanent position. And then they have to test the US labor market. We call it recruitment, but it's really testing the US labor market to make sure that we're protecting the US workers, that there's no minimally qualified US workers for that. Once they've done that, then they can submit that that application for final certification from the Department of Labor. Once that comes back, that's when the company can then switch gears from working with the Department of Labor and now file an immigrant petition with Immigration Services, which would form the basis for you to be able to then go to stage 3, which is apply for your green card. In some cases, if you're in a backlogged country and you're in an EB2 or an EB3 category, there's going to be a long queue. And that's where it comes. Early planning and trying to make sure you have an underlying status is really crucial. This is more details about the labor certification process, but it does require that the government or that the business makes that attestation to the Department of Labor that they're not going to take away a job from a US worker. It's meant to protect the US workers, so they have to test that US labor market. There are some occupations that are a little bit treated differently. That's if you're a university professor, university or college professor, or if you're in an identified occupation like a nurse or a physical therapist. But that's the labor certification process. And that process alone takes about 1 year. So it's a very time-consuming process. And then once you get to that labor certification process, or if you are applying on a basis where you don't have to do the labor certification process, so the EB1A or a national interest waiver, then you can just file the immigrant petition. And so the petitioner has to file that petition, and they have to have the ability to pay that position as well. So that's one of the other requirements if it's a sponsored position. Now, if you're going to be in a non-backlogged category, then you can also file for your green card at the same time. Now, when you're filing for your green card, you have to show that you're admissible, meaning you're maintaining your status. You're adjusting and changing your status. And when you do that, you have to meet certain admissibility questions. And when USCIS is reviewing that, they're also going to go back to that visa bulletin to make sure that there's an available visa available, an available green card available. So they are looking at the visa bulletin first to make sure you can file for your green card, but then at the same time, USCIS looks at it again to make sure that there's a available number by the time, the months later when they go to file for the green card. Now that EB1A, that's the position, that's the category that you can self-file, self-sponsor. You don't have to go through the labor certification process because we want people of extraordinary ability. But again, when you're a recent graduate, it's a little bit harder. It's a harder category to satisfy when you're just graduating and starting your academic career, because as Prasant said, you have to show that you're already at the very top of your field. So there are some situations where it might be realistic, but the other times it's a much harder sell, and you're probably more likely for a professional type of position, going to look at the labor certification process. But it's a similar criteria as the O1. Now, the national interest waiver is a really great option because it can be self-sponsored, and you have to have, because it's EB2, you have to have the equivalent of a master's degree or higher. Now, the criteria are also a little bit different than the EB1A. Here, you just have to show that your work, that, the work that you're doing has substantial merit and national importance. And what does that mean? It can be anything from promoting economic development. It can be from improving healthcare, improving educational training programs. That's not just simply being a teacher, although that is a very commendable profession. It has to be developing new materials or programs that can help in a greater scheme, a greater national scope. And then you have to show that you're well positioned to continue to advance that endeavor. And you do that based on showing the work that you've done already. So your past work or performances are indicative of what you're going to be able to continue to do. And then on balance, this is where we're asking the government to discretionarily waive that labor certification process, that it's beneficial to waive the job offer and that testing of the US labor market. One of the new policies that just came out, I think, was it even just January maybe, right? The current administration has recognized the importance of STEM and as a national importance. It's a substantial merit and national importance. So now they're looking to see if you're going to be engaged in any of the STEM fields to improve US competitiveness. So it's really sort of expanded what people are going to be able to show as what their background and how they're going to help the national interest, whether it be national security or just economic competitiveness. And it also did have some language about entrepreneurs. So it's a much more favorable landscape for self-sponsoring when you're in that STEM field or an entrepreneur. And then in terms of family categories, there are options as well. Like the employment side, that you also have to look, they have a similar category, or they break down by categories. And if you are sponsored by a US citizen and you're a parent, child, or an immediate or an unmarried minor child, then you're called an immediate relative. And so there's no quota, and you can adjust anytime. You don't need to worry about having to look at the visa bulletin to see if there's a different category and a backlog and a time frame. So when people are thinking about family-based categories, it's not open to everybody. It's really only open to being sponsored by a US, if you're being sponsored by a US citizen, you can only sponsor a parent, spouse, unmarried child, son or daughter, or brother and sister. But those categories then are subject to the visa bulletin and at considerable weight. You're looking at 15 years or so for a brother or sister. So it's nothing immediate. And then in terms of if you're getting married or you're having a US lawful permanent resident, a green card holder, they can sponsor for a spouse or an unmarried son or daughter, but they have to look at the visa bulletin to make sure it's current. So there are some options for the family based, but in terms of employment based, it's really important to plan ahead. And I mean, if you saw the, you know, as I mentioned, the labor certification process alone takes a year. And so you need to make sure that you have some sort of underlying non-immigrant status to carry you through. And if you're subject to a very long visa wait or a very long green card wait from a country like India or China, you know, and if you have to wait 5 years and you don't have an underlying visa, you can't just hop from your F1 student visa to a green card. So it takes a lot of early planning and asking questions of your employer and hopefully also attorneys to get good advice. And in terms of lots of different things changing, there are always new developments like the national interest waiver. They've expanded some of the 01 guidance, which is also helpful to the STEM fields. You're always welcome to sign up for our newsletter and get some of those new updates.